put it out now, before we start the meeting, that if there is a reason that you think that you would want to withdraw, I think we would consider allowing withdrawal without prejudice tonight until we sit with a full board. That's strictly up to you. 4 votes will, in the affirmative, will pass any petition tonight. Okay. So the first hearing this evening was filed by William Ruprecht of Oliver Avenue, and it's an appeal to the Assistant Building Commissioner's determination under the zoning ordinance and under Mass General Law, Chapter 40A, that the lot in question is not a buildable lot. The premises affected are situated at Oliver Avenue, located in an R12 zone. And there is an analysis, and I believe, is Mr. Rupert here? Okay. Let me just get this into the record, and then I would ask you to come up, sir. The applicant owns and resides at 92 Cummings Avenue. The 6,011 square foot property in question, which is identified as I-2-7-29, abuts 92 Cummings Avenue to the north. In response to a letter drafted by the applicant, Mr. Ruprecht, dated May 16th of this year, the Assistant Building Commissioner indicated that the lot does not meet the criteria for a building lot under the current zoning ordinance. He stated that the lot falls within the R12 one-family residential zone, which requires a minimum of 12,000 square feet of lot area and 60 feet of frontage. The Commissioner stated that the frontage requirement is met, but the lot is 6,011 square feet and thus far below the 12,000 square foot required. In the letter, the Commissioner notes that the relevant section of MGL Chapter 40A, under which non-conforming lots are afforded buildable status, could not be applied to the circumstance. The applicant has filed an appeal based on the building inspector's determination that I-2-7-29 is not a buildable lot based upon the requirements of the City of Pittsfield zoning ordinance and Chapter 40A. Lot's currently valued at $2,100. The analysis is as follows. In 1994, Mr. Ruprecht's mother, Mary, executed a deed to the Cummings Avenue property, reserving a life estate and conveying the remainder to him. In 1998, Mr. Ruprecht conveyed the Oliver Avenue property to himself and his mother jointly. Mr. Ruprecht has enclosed a letter drafted by attorney Mike Shepard, dated June 18, 2003, requesting a determination from the city as to whether the property was a buildable lot. In 2 subsequent letters issued by the city solicitor on May 12, 2004 and June 29th of that year, respectfully, Mr. Ruprecht was informed that his parcel did not meet the requirements for a buildable lot. Both letters are included herein and cite relevant case law in Chapter 40A of the Mass General Law supporting the solicitor's opinion. In July of 2006, Mr. Ruprecht sued the City of Pittsfield through U.S. District Court for the sum of $60,000. And this suit was based on a variety of claims. Mr. Ruprecht's claims were dismissed without prejudice based upon the fact that his allegations could not be substantiated. On May 31st, 2007, Mr. Ruprecht appealed the matter to the First Circuit U.S. Court of Appeals, which consisted of a 3-judge panel, and who determined that Mr. Ruprecht made no showing that he satisfied the requirements for such an appeal. The Circuit Court took 1 year to finalize the denial for appeal, however, did issue a rejection of the appeal on June 13, 2008. On May 14, 2009, a conference call was held between Mr. Ruprecht, the Assistant Building Commissioner Gerald Garner, the City Solicitor, and the Massachusetts Land Court. At this meeting, it was determined that the matter would need to be heard before the local zoning board of appeals before it could come back before land court, and thus a post-hearing order was issued, and a date was set for August 27th of this year. On May 16th, 2009, Mr. Ruprecht submitted a letter to the building department requesting a determination from the current building commissioner as to whether or not lot I-2-7-29 was buildable or not. A response was drafted by the building department that the lot was not buildable, and it's based on this letter that Mr. Ruprecht is appealing to the ZBA. Essentially, Mr. Ruprecht is pursuing the same determination that he sought in 2004 regarding the status of the lot. So in summary, it appears that the issue has been thoroughly reviewed by numerous City of Pittsfield representatives in addition to judicial bodies. Based on the requirements of the zoning ordinance relating to the minimum lot size requirements for parcels within an R12 zone, the lot in question does not meet the intensity requirements set forth. And in addition, Chapter 40A, Section 6 does not apply to the lot in question, and therefore doesn't qualify as a building lot. Should the board find the appeal submitted by Mr. Ruprecht to be valid and that the lot in question should qualify as a building lot under both the City of Pittsfield zoning ordinance and MGL, it is recommended that they adopt the staff findings and analysis and require the following conditions: that all building department permits be secured prior to the commencement of any construction on the site, and the applicant is subject to all of the local, federal, state, and local rules and regulations. So there's a lot of paper on this case, so I think it makes sense at this point to call on the applicant to come forward. Just state your name and address for the record, sir.
William Ruprecht, 92 Cummings Avenue, Pittsfield.
Okay. Would you want to comment on this or add any more information?
Well, I mean, I would just go with what I wrote on my page 1 of my submittal.
We just received this, so.
Yeah, I'm sorry.
Maybe you want to summarize from it?
Yeah, enforcing the doctrinal lot merger would devalue the Oliver lot to such a degree that it would amount to an undue hardship. On page 5, the city had it valued at one time at $37,400. The current valuation is $2,100. Another question would be, can you compel merger with an unimproved lot and an improved lot? Cases in Maine indicate that you cannot. And they use cases from New Jersey. The forms of ownership are different. My mother, 92 Cummings Avenue, is a life estate, and we have joint tenancy on Oliver Avenue.
You live next door to where she's
No, I live in
residing?
my mother's house. She's living at assisted living.
Okay, so, but the lot, I guess I should say, the lot next door is your lot?
Yes, I bought that in 1975.
Okay. And the information here is correct that the other lot was conveyed in 1998, I believe, 94 or 98?
Yeah, that was for survivorship purposes.
Okay. So I think the question that you have some ownership in both lots.
Well, I'm the remainder man on the life estate. I don't have control over it.
After she dies,
Right.
then you would take
Right.
the lot. Okay. Questions for the applicant?
That's jointly owned right now,
The house,
that lot?
the
is
vacant lot is
jointly owned by both you and your mother?
Yes.
Well, I think that's not exactly accurate, is it?
Well, it's a joint tenancy.
So you basically have control over both lots.
No, I don't.